Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President, bills brought from the House of Representatives, petitions, papers.
Minister in the Ministry of Finance.
Madam President, I have the honor to lay on the table the following papers as listed on the supplemental order paper in the name of the Minister of Finance. The public accounts of the Republic of Trinidad and Tobago for the financial year 2019, the value-added tax bond payment refund amendment regulations 2020, and the value-added tax bond payment refund amendment number 2 regulations 2020. Thank you, Madam President.
Reports from committees, urgent questions.
Senator Mark.
Thank you, Madam President. To the Honorable Minister of National Security. In light of reports that members of the Trinidad and Tobago Police Service stopped the sale of prepackaged doubles and other prepackaged meals at St. Christopher's service station, can the Minister advise as to the legal basis for such action?
Minister of National Security.
Thank you very much, Madam President. Madam President, I'd like to start by just taking the opportunity to thank all of the men and women in the Trinidad and Tobago Police Service who, during this time of great uncertainty, as a country deals with the measures implemented to put in place to deal with COVID-19, which for those who have missed it is a global pandemic, have had the unenviable task of interpreting regulations and ensuring as best as they can, this is the men and women in Trinidad and Tobago Police Service, that the measures and the policies that the government has put in place to keep the population safe are maintained. It is not an easy task with between 5,000 to 7,000 police officers out protecting us, the population, to be called upon at any given moment in time to interpret the regulations. This question and the mischief behind it are rejected, and in fact, facts have overtaken, because as soon as the Commissioner of Police became aware of this particular incident, he moved with alacrity and certainty after consulting with the Minister of National Security and put out an apology. We are not always, we meaning the Trinidad and Tobago Police Service, are not always going to get it right. But I take the opportunity to thank them for being on the front line and protecting the population of Trinidad and Tobago. I thank them, I thank the men and women in the Defense Force, in Immigration, in Customs, or health workers, and all of those, the fire service or prison officers, for taking on the fight of COVID and doing so knowing that they must protect the population and rejecting the naked politics that certain people try to keep inserting into the battle against COVID. Thank you.
Senator Mark.
There is no naked politics or mischief. Madam President, may I, through you, ask the Honorable Minister may I address you and not be disturbed? May I ask the Honorable Minister what measures are being taken to ensure that the hard-working men and women of the police service who have to interpret, as we were told, these regulations, what measures are being taken to avoid these unnecessary errors of judgment by these officers in dealing with the public on sensitive matters as outlined in the regulations?
Minister.
Madam President, in the day-to-day policing of any country, any state, any sovereign nation, as I said, the officers who are on the front line will have different interpretations. What happens with the police service is the commissioner meets with his executive via Comstat and via other meetings. On a daily basis, the commissioner, the CDS, other members of the national security team meet with me. We have a daily briefing and discussion. It doesn't stop the men and women who are put in the situations of making decisions out there from making errors. This was an innocent error made, and let me tell you why it was made. I suspect why it was made. It's because there are still persons who are trying to find loopholes in the regulations. There's still certain restaurants, because restaurants aren't allowed to be open. So there's still certain restaurants that are cooking food, freezing food, and trying with delivery service, curbside service, etc. So maybe that is what the police officers were after. This matter was corrected within a matter of minutes. It was not hours. And I commend the commissioner and the men and the women of the police service for the manner in which they handle this situation.
Then, is the minister accusing Massey Stores, a financier of the PNM, of being involved in mischief or being engaged in activities which is totally against the regulations in the context of having on their supermarket shelves pre-packaged food items, Madam President?
Senator Mark, that question is not allowed.
Questions on notice, questions for oral answer.
Acting Leader of Government Business.
President, there are 4 questions on notice for oral answer. The government intends to answer all 4 questions, Madam President.
Senator Mark.
Thank you, Madam President. Question number 55 to the Minister of Community Development, Culture, and the Arts.
Acting Leader of Government Business.
Madam President, I thank my colleague Senator Mark for this question. In relation to the first part of the question, the actual sums owed to suppliers and artists from the staging of Carifesta 2019, based on invoices received by the Ministry of Community Development, Culture and the Arts, is $1,873,176.60. The suppliers and the artists to whom these monies are owed as at April 29, 2020 are as follows: Ameladis Caballero, Marissa Nimrod, Kerry-Ann Small, National Carnival Commission, Shariz Arjun, Ian Daniel, Sherry Connell, Khalida Constantine, Marita Bartholomew, Joseph Pulchan, Mr. Alfred Liamu, David King, Brandon's Events Rental, Holistic Music School, Trinbago Commercial Development Company, Country Boys Tassa Group, Risk Management Services Limited, Copyright Association, Renter Amp, and Johnny Q Sound Company. And in relation to the third part, it is expected that all payments will be made by the end of June 2020. I thank you.
Senator Mark.
Can the minister explain what is responsible for this unusual delay of payments after Carifesta was held a couple months ago? Can the minister indicate what were the factors or the reasons leading to these outstanding payments to the various persons identified?
Minister.
Madam President, my colleague Senator Mark was himself a Minister of Government, and he understands that a variety of factors are involved. One is the timing of this, so that Carifesta was held very close to the end of the last fiscal year, so that some payments, if the invoices were received and processed before the end of the last fiscal year, those payments would have been processed. And those payments, those invoices which were received after the start of the new fiscal year would have been in a position to be processed about October, November last year. That's one factor. The second factor would have been the actual receipt of the invoices and the dealing with any queries and additional information required on the invoices. My friend knows how tedious it could be and how the rules of the public service in relation to the Exchequer and Audit Act puts an onerous responsibility on public servants, in particular permanent secretaries, to verify payments which are required. And thirdly, the process of requesting releases and ensuring that funds are available to allow the comptroller to authorize the printing of the checks and the issue of the checks to the person. So that process, I would say to my friend, has resulted in I would not call it delays. We've had issues in this country with panmen and with calypsonians and with suppliers, contractors having to wait years sometimes for payment. So while we regret any delay, it is not unusual, and the minister has said by the end of June, these payments which are to be made will be made. I thank you.
Senator Mark.
Madam President, can I ask my honorable colleague, how come these artists waiting for all these months for $1.8 million? How come, Madam President, through you, the government is unable to find this money to pay these artists, but is able to find millions of dollars to pay 4 private security firms to supposedly patrol communities in this country without any tendering process?
Senator Mark, that question does not arise. Next question.
Madam President, can the minister indicate whether the real reason, what is the fundamental reason? Is it that the government is suffering from a serious cash flow problem to identify $1.8 million to pay these artists? Can the minister explain, Madam President, through you?
Senator Mark, that question is not allowed.
Madam President, can the minister give this Parliament a firm undertaking that these outstanding monies owed to these artists will be honored as he has indicated to us by June of 2020? Can I get that undertaken from the Honourable Minister?
Senator Mark, that is also not allowed. Next question, Senator Mark.
Question number 73 to the Minister of Health.
Acting Leader of Government Business.
Again.
I thank my colleague Senator Mark for this question, a very important question. In relation to the first part of the question, the answer is very simply yes. The vaccines which have been purchased are sufficient. And in relation to the second part of the question, which is contingent on the first part being yes, I would say that the Ministry of Health has been very aggressive, Madam President, taking into consideration that there has been an anti-vaccine movement around the world, but in Trinidad and Tobago also. And within this Parliament and outside this Parliament, there has been some anti-vaccine voices. And the Ministry of Health has been very aggressive, particularly on the radio and through the primary health facilities, the community facilities, in getting people to understand the importance of taking the vaccine in the context of the potential of getting ill. Madam President, the communication program is built around one very important concept, and that is that not everybody needs to have the vaccination. The focus is on the high-risk group, which would be children aged 6 months to 5 years, adults over 65 whose immune system is compromised by diabetes, hypertension, and obesity, persons on immune suppressant drugs with respiratory diseases, and pregnant persons. So this is the group that is being focused on. The information is disseminated via the radio and through the primary public health facilities in the community in particular, and through the ministries and the state enterprises. Madam President, I dare say that it's been done through the Parliament, because I myself had to remove my shirt and have my shot, and I'm very happy to have done that. And I encourage the citizens of this country to do the same and get the vaccine. And the Ministry of Health is confident that there are enough supplies in the country to do that. Thank you very much.
Senator Mark.
Madam President, in light of the influenza virus being adequately contained, can the Minister explain why so many citizens between September of last year to the present time have perished, have died as a result of this influenza virus? Can the Minister explain?
Minister.
Madam President, let me explain it in this way, because my colleague seems to be back on the issue of sufficiency of the vaccines. And if I may assist, during the period, let me just say this, during the period 2010 to 2014, for example, that is when my friends were in government, the amount of vaccines purchased during that period was 85,900 doses. And of that 85,900 doses, only 54% were used. So it means that 46% of that small sum expired and was not utilized. Compared to the period 2015 to now, and the amount purchased, the vaccines purchased by this government under the very able Member of Parliament for St. Joseph, the Minister of Health, Terence Dial Singh, the number of vaccines have increased by 534%. So we've moved from 85,900 to over 500,000 doses. That is a serious change. And Madam President, of that stock that has been purchased so far, the utilization rate is 73%. 400,000 have been used. So that, Madam President, for the 2019-2020 influenza season, the ministry has procured 159,200 doses. And as at May 4, 2020, that is yesterday, 112,000 have been used, which is a utilization rate of 70.7%. So it means that the Minister of Health is procuring more vaccines. The vaccines which have been procured have a much higher utilization rate. And in the current season, the utilization rate is above 70%. And that alone should signal the vast improvement and the serious approach the Minister of Health has taken in relation to this issue of the influenza. I thank you.
Senator Mark.
Madam President, given the high utilization rate, as outlined by my good friend, Senator the Honorable Clarence Rambert, can the Honorable Minister indicate to the Senate how many people have died as a result of the influenza virus for the period September 2019 to the present?
Minister.
Madam President, that is an important question. I know it has been provided by my colleague, the Minister of Health, and I would provide that information in writing within 1 week. Thank you.
Senator Mark.
Madam President, can the Minister indicate at this time how many influenza vaccines are still available, and when are they? How many influenza vaccines are still available for public access, at this time?
Certainly. So let's do some maths. For this year, 159,200 vaccines have been procured and are available. As of yesterday, 112,645 doses were used. So, Madam President, I would say that about 47,000 vaccines are available now, which is 30% of what was procured originally. I thank you.
Senator Mark?
Can I ask the Honorable Senator, through you, Madam President, when are these vaccines expected to be expired? Is there an expiration date for these vaccines? May I ask the Honorable Minister?
Minister?
Madam President, my friend has stretched me to a point where I can no longer reach. I'm unable to answer that.
Next question, Senator Mark.
Oh, sorry. Thank you, Madam President. I stretch you also the Venezuelans, eh? Espanol. Oh God, I felt sorry for you last night. Anyway, Madam President, may I ask through you, question number 74 to the Honorable Minister of Labour and Small Enterprise Development.
Minister of Labour and Small Enterprise Development.
Thank you very much, Madam President. Madam President, the Ministry of Labour and Small Enterprise Development seeks at all times to have and will have on the manufacturers
and other taxes. Has the Minister been able to determine what impact this will have on government revenues?
Senator Mark, that question does not arise.
Madam President, can the Minister indicate whether she's aware of the total labor force or the total workforce of Unilever? Can the Honorable Minister indicate, in other words, Madam President, whether the government anticipates further retrenchment at this company?
Senator Mark, that question also does not arise.
Madam President, may I, and to other jurisdictions, what efforts are being made by the government to encourage those companies to maintain their operations in this country?
Senator Mark, that question also does not arise. Next question, Senator Mark.
Thank you, Madam President. Question number 75 rather, to the Prime Minister.
Acting Leader of Government Business.
Madam President, in relation to the question, the information provided is as follows. My brother and asked if she could have posed a few questions to the elector. The brother agreed. The elector was asked her name, she did not answer. The elector was asked her age, she did not answer. The elector was then asked where she lived, and she did not answer. Repeated attempts by the presiding officer to elicit a response from the elector in these and related questions proved futile. The elector's brother, her companion, as defined under Election Rule 48(4)(b) of the Representation of the People Act.
Madam President, it is indeed a pleasure and a privilege to be here today, even as we as a country are facing measures put in place to deal with the global pandemic that is COVID-19. Legislation that is seen as important and as this by the government of Trinidad and Tobago, and that is a bill to amend the Administration of Justice Electronic Monitoring Act 2012. Madam President, offense committed in lieu of a sentence of imprisonment or as implementing and maintaining a system for electronic monitoring in accordance with Section 4.1 of the Act. The unit will provide, inter alia, real-time tracking of the location of persons placed on electronic monitoring and report any alarm notifications, signal loss and device malfunction to the police or the relevant personnel. The unit has been staffed. These staff members include the manager, the deputy manager, liaison officer, shift monitoring operators, and business operating coordinator. The unit has also developed several standard operating procedures and conducted numerous outreach exercises and workshops. Madam President, at this stage, I'd like to thank the electronic for us being able to greenlight this system. The system is ready, the system can be operationalized, and it requires some more required hardware and software for the system, both at the main site and at the backup site, has been completed, and the devices were tested throughout Trinidad and Tobago. I pause here, Madam President, to just put on record as well, the award of that contract was via a competitive tendering process undertaken by iGov Trinidad and Tobago. The letter of award was Amalgamated Trinidad and Amalgamated Security successful bidder, and they were so informed in January 2019, with a contract being executed in April 2019 to provide the City Services Limited and an Israeli company that they partnered with called Attenti Limited, a turnkey electronic monitoring solution I've just referred to, with installation not only at the main command center, but also of a backup site of hardware and software. The contract included the supply of 300 devices, ankle monitors, the training of staff, the commissioning and maintenance of the system for a period of 3 years at a contract cost of 10.3 monitoring unit can notify that if the person wearing the ankle bracelet comes out of a parameter zone or comes within a certain amount of distance to the potential victim, an alarm will go off. The electronic monitoring unit will notify the Trinidad and Tobago Police Service, but also the potential, all totaling the amount of $10.3 million over this 3-year period. The system is operational, and all we await now to be able to implement it fully is the passage of this legislation. I'd like to say that, Madam President, through you, I'd like to thank all of those on that committee, as well as my colleague, the Honorable Attorney General, for the yeoman service and the work that they did in a consultative manner to be able to produce this legislation here today, these 25 clauses that will finally bring the law in line with how it needs to be, and as I will get to in a short while, allow the judiciary more extensive discretion in how they apply the use of this technology going forward through various orders, not only in domestic violence legislation and orders, but also in other areas, for making us a safer and more secure environment in Trinidad and Tobago. C, making provisions for an applicant who is granted a protection order to consent to being issued a protection device that would monitor, inform, and alert the applicant if the person against whom the protection order is made comes within the specified proximity of the applicant. This is what I was referring to a short while ago, Madam President, allowing potential victims of domestic violence the safety and security of an alert system, knowing that the police would be able to respond on an immediate basis through the use of the ERP vehicles and dispatching police officers to be able to protect a potential victim if one wearing an ankle bracelet by order of the court breaches the parameters. Government's policy is that as soon as we're able to proclaim this act, which we hope will be in the not too distant future, we're hoping within the next week, within passage of this act, that we would be able to work now along with the court system and focus our priority in the launch of the implementation or operations of this.
You finish at 2 minutes past 11.
Okay, thank you very much, Madam Speaker. So, Madam Speaker, now to just quickly take us through the clauses and the purpose behind the clauses. Clause 4 of the bill is an insertion of definitions for words not previously defined in the Act. New definitions as a result of proposed amendments and amendments of words previously defined. For example, authorized officer, defined as it's used in the proposed new section 4A. Court is being amended to reflect the current judicial positions in the criminal justice system. A lot of emphasis has been placed by this administration over the past 4.5 years of reforming as best as it could, of working along with the judiciary, the criminal justice system, introducing masters into the system, removing registrars from the magistrates' court, and these other types of newly created positions, so they'll now be captured by this new definition. Occupier is used in the Act, but was not defined previously. The definition of occupier is defined broadly to include any person exercising control over the premises, which would include licensees and the holders of a power of attorney, etc. The protection device, the definition is now included as this term is proposed to be used in the new section 10A. The definition of electronic monitoring devices was amended to include telecommunications network as part of the electronic monitoring system. This change allows the use of a broader spectrum of technology that currently exists to allow the tracking of these devices and to be able to pinpoint exactly where the ankle bracelet, the person wearing the ankle bracelet is positioned to allow a better monitoring process. The definition of respondent was amended by deleting the words "or against whom a protection order is granted" under the Domestic Violence Act. This proposed amendment restricts the definition of respondent to include only persons against whom a protection order is made. Clause 5 of the bill, Madam President, is the insertion of a new section 4A to provide for the director to delegate his or her functions. The director would be able to delegate his or her functions under the Act. The director performs many critical functions, Madam President, which include, for example, providing the court with a director's report. This express and specific amendment allows that director to now delegate these functions, therefore not grinding to a halt the whole system in case of the absence of the director. It now allows a specific power to delegate. Clause 6 is the insertion of a new section 6A to empower the director to issue standard operating procedures. These standard operating procedures, Madam President, are to protect the users of the system, the end users of the system, those who utilize the system in any which way. And these standard operating procedures have already been drafted and are in place. Clause 7. Section 8 is repealed and replaced with an amended Section 8 that provides for confidentiality of information, Madam President. The proposed amendment ensures that all employees of the unit take an oath of secrecy to not disclose any information received from the unit other than the proper course of their employment. Disclosure of the information in contravention of the oath is a summary offense. This amendment provides for a more robust system to ensure confidentiality of persons employed with the unit and the end users of the system. I pause at this juncture, Madam President, just to put on record one of the attempts to push back at these amendments in the other place was the suggestion that to use contract workers as opposed to public servants there's something wrong, inconsistent, unusual about that. We reject that outright. There is absolutely no unit, no division, no ministry, no organization within the public service that does not currently use contract workers. Remember, the system is now being set up, and it is better to use the contract workers in the first instance as the system rolls out and we see how it works. At the appropriate time, permanency of positions can be taken to the Public Service Commission. At this stage, it was felt that we just needed to get on with this long outstanding and very necessary set of technology. Clause 8 inserts a new subsection 10(2)(c), D, and E. This amendment gives the court a greater discretion in the imposition of electronic monitoring, Madam President. Under the Act, the current section 10, subsection 2, specify that the court may also impose electronic monitoring as a condition of bail or protection order made under Section 5 of the Domestic Violence Act. The amendment now includes probation orders under the Probation of Offenders Act, community service orders under the Community Service Act, as well as a catch-all which allows the court to exercise discretion in cases deemed fit. Therefore, Madam President, this amendment gives the court greater discretion to determine when an electronic monitoring system, bracelet, can be imposed or should be imposed. Again, this goes back, Madam President, to some of the examples I was giving previously to allow, for example, first instance offenders, young offenders, the opportunity to not be incarcerated, but rather to have this ankle bracelet on as part of their bail conditions or even as part of their sentencing. And it just allows a greater flexibility for reform of those types of persons and also others who may not be the best position to be incarcerated. Clause 8 inserts a new section 10(3)(a). The new clause gives the court the discretion to impose electronic monitoring as a condition of bail for offenses listed in the first schedule, where bail is granted, or in the case of a child, a very important exception and a very important power. This is essential as the first schedule offenses include various offenses such as shooting or wounding with intent to do grievous bodily harm, trafficking in dangerous drugs, kidnapping, etc. The amendment makes it clear that persons charged with these serious offenses, once out on bail, that the court can impose electronic monitoring as a condition of bail. One of the struggles right now in law enforcement, Madam President, is that persons who are charged with these offenses, when granted bail, there is no real-time way of monitoring them. There's the old system of going to the nearest police station and having a copybook signed in. But what we're doing now is allowing technology to be utilized, especially on some of these more serious offenders. Clause 8 amends Section 10, subsection 5 and 7 by deleting "the court shall commit the person to custody" and replacing it with "may commit to custody or grant bail as the court deems fit." Clause 9 inserts a new section 10A that provides for protection devices safeguard an applicant who obtains a protection order. So this now, Madam President, makes provision for the applicant to consent to being issued with a protection device. The device would ensure that persons against whom the protection order is made do not come within a specified proximity of the applicant. In the event of a breach, an alarm would sound. The electronic monitoring unit would activate its protocols, including contacting the victim, giving instructions to the offender, and escalating to the police response mechanism as is required. Clause 10 inserts a new subclause 11.2. This proposed amendment allows for decision makers when determining whether to grant a pardon to request a report from the director. Clause 12 amends Section 13.1 by repealing it and replacing it with a new Section 13.1. This amendment removed the requirement for the application form to be prescribed. The required form would now be created by the Rules Committee of the Judiciary and would form part of the rules to be developed for electronic monitoring. The requirement that the criteria for application be prescribed by regulations was also removed to allow for greater judicial discretion. Clause 14 inserts a new Section 16.1a that deals with individuals who negligently damage the device. This now provides and allows for the state to make these persons liable for the replacement cost of the device if damage was due to negligence. Additionally, the person monitored would also be brought back to court or the competent authority to determine if he or she would continue in the program. Clause 14 amends also Section 16.3 to allow the court to send copies of the order to any other party the court considers necessary to inform.
Minister, you have 5 more minutes.
Thank you very much, Madam President. Clause 15 of the bill provides for an amendment to Section 18.2 by providing for the breach to be reported to a police officer in charge of rather than a police officer in charge of a station in the magisterial district, to bring it in line with what currently applies, that if there's any breach, you could report it at any police station. So rather than the archaic terminology of old legislation that you must go to the magisterial district, it now provides greater flexibility that any police station, a report can be made. Clause 16 inserts a new Section 19.2a that provides for the director to notify the court forthwith of any proposed change in circumstances. Clause 17 repeals Section 22.2. This section provided for Section 14b of the Evidence Act to apply. Clause 19 deletes Sections 25.1b, c, and f. The deleted subsections were considered to be matters that should be left up to the court's discretion. Clause 20 inserts, Madam President, a new Section 25a to allow the Rules Committee to make rules of court for this act. This insertion allows them to do exactly what we've described. The 4th schedule, Madam President, introduces the oath of secrecy. Madam President, with the greatest of respect, and to the senators who will enter the debate today and for the senators who will subsequently vote on the passage of this legislation, I ask you as a mover and a piloter of this legislation to please support it so that we may get on for long, outstanding use of technology. We are ready to implement it. There can only be benefits from the use of this technology, and these benefits in the first instance we hope will redound to the benefit of those who suffer the scourge of domestic violence and also some of our young offenders, to give them those opportunities in life. We are ready to implement. I thank all of those who participated in the preparation of these few amendments to allow us to be able to implement and finally operationalize this important piece of technology in national security in our continued fight against criminality and providing a safer and more secure Trinidad and Tobago. Madam President, it would also be an opportune moment for me to apologize for my impending departure and to say that the Attorney General will have the opportunity on behalf of the government to do the wrapping up as we get to that point, and to thank everyone for their attention. And I look forward to the support for the passage of this important bill, this important piece of legislation, so we in Trinidad and Tobago can finally move towards the utilization of this technology. Thank you very much, Madam President.
Minister, I need some words from you.
I beg to move, Madam President.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Administration of Justice Electronic Monitoring Act 2012 be now read a second time. Senator Mark, you have 30 minutes.
Thank you. Thank you, Madam President. Madam President, the bill before us is an act to amend the Administration of Justice Electronic Monitoring Act of 2012. Madam President, this bill has its origins in the Parent Act of 2012, which was passed by the People's Partnership government as part of a trilogy of criminal justice bills with a view to transforming and modernizing the criminal justice landscape in our country. The then Minister of Justice stated, and I quote, "This is just one of the measures proposed by our government to overhaul the penal system by introducing a new sentencing option which would have the effect of reducing prison overcrowding and introducing a more effective prisoner management system." End of quote. Madam President, this act was assented to in 2012. But sadly, without the support of the PNM, both houses, in the both houses of Parliament, the Senate, and in the House of Representatives, the PNM voted against this very important piece of legislation. And Madam President, I will let you know in doing the research on this matter that whilst this was passed in 2012 and we limited office in 2015, the PNM came into office in 2015 and they're about to leave office in 2020. It took the PNM 4 years and a half in order, Madam President, to bring changes to the legislation. And today, on their way out, they have now brought amendments to deal with this matter of strengthening the Electronic Monitoring Administration of Justice Act of 2012. Madam President, as I proceed, I will refer to my dear friend, the Attorney General, who was very vociferous in his objections to this bill, which became an act in 2012, and some of the arguments that were advanced in order to justify his opposition to this bill in the period mentioned. Madam President, when we look at this bill very carefully, we would see that this bill has taken the form of many, many manifestations. And there's a report that I want to refer to called the 7th report of the JSC on Finance and Legal Affairs, in which, in that report, it was stated that one, and we have confirmed this today, the electronic monitoring unit has been formalized, has been established, up and running. We know of its location on Tragarete Road in Port-of-Spain. We know, Madam President, that 300 electronic monitoring devices have been acquired by the EMU. We know, Madam President, that 361 officers have been trained for this exercise and sensitized to this very important initiative. Madam President, we are also conscious that in the Parent Act, there is provision both for public offices to be created via the director and the deputy director under Section 121 of the Constitution. But we also know that there were interim measures in the very legislation to permit the engagement of contract officers. What we do know, Madam President, is that in the electronic monitoring unit of the Ministry of National Security, we do have on board 2 powerful office holders. The general manager, who under the public service arrangement is known as the director. He has been employed for almost 2 years now. 2 years. And then we have the deputy manager. I suspect, Madam President, and I can be corrected, he too might have been employed for a similar period of time. But even though these people have been on board for 2 years, although the contract has been executed for 1 year, Madam President, it is as if the earth has stood still. There is no pilot project. This was one of the arguments that the then Senator Faris Alwari, now Attorney General, piloted, promoted, prosecuted, the need for a pilot project. Madam President, we are going into this amendment, we are debating this amendment, and there is no pilot project, and there is no testing period, Madam President, as it relates to this initiative. What we do have is a contract that has been executed by the government through ICOM-TT, and the winner has been Amalgamated Security Services Limited, with an Israeli firm called Atenti, and the value of the contract is $10.3 million. Madam President, this is the same Amalgamated that has a contract, according to the minister's statement, I have a copy of, $24 to $25 million to transport prisoners. So this one private company is involved in 2 streams within national security. They are providing the software and the hardware. They are maintaining the software and the hardware. They are conducting training on this very important area. and they are involved, Madam President, in the transportation of prisoners. This must be cause for concern as it relates to conflict and threat. Well, I won't say threats, but concerns as it relates to national security, to have one private agency being responsible for two critical sectors or areas within national security. Madam President, we know this bill in its current form is supposed to deal with domestic violence. So those people who are aggressing our women, 97% of the cases deals with that in this country. And we have had thousands of cases of domestic violence in this country. So this is one of the, I would say one of the promises and one of the main driving forces between, as it relates to this bill, to protect our women through protection orders and through the court having these individuals ankle brace or issued with bracelets, ankle bracelets, so that they can monitor and be monitored by the appropriate authorities. And of course, Madam President, prisoners. We know that the government has been talking about COVID-19, and they have gone before the courts to see if they could get about 388 or thereabout prisoners released early, and maybe this system is designed to assist in achieving that objective, Madam President. So we know that the government is interested in these areas, and that is a matter that certainly we have no problem with. Non-violent offenders can qualify. Persons who fail to pay maintenance, traffic offenses, using obscene language, marijuana possession, resisting arrest. These are some of the categories that will benefit from this electronic monitoring exercise, Madam President. Madam President, I would like to ask the Honorable Attorney General, it is our parent bill, so any attempt to strengthen it will certainly be welcomed. And therefore, I have no difficulty in asking the Attorney General to look at certain specific sections of this legislation to determine if they require a special constitutional 3/5 majority. And if they do, Madam President, we are willing to sit with the government and correct the deficiencies of the legislation that is before us. Madam President, I would say that there's need for the government to pay attention, and the Attorney General to pay attention to Clause 8 of the bill, which seeks to amend Section 10 by expanding the grounds on which a court may impose a sentence of electronic monitoring. We are expanding the power of the court to impose, Madam President, a sentence of electronic monitoring. I think that is an area of concern, and the AG would be well advised to look at Clause 8 of the bill, Madam President. Madam President, another clause of the bill that we would like the AG to look at in the context of its collision with Sections 4 and 5 of the Constitution is Clause 13 of the bill, which seeks to amend Section 15 by extending the category of who may pay for use of the electronic monitoring device. Madam President, it may be argued that the payment of user fees is a form of discrimination against youths and the poor. And therefore, Madam President, the right of citizens or the right of the individual to equality before the law and the protection of the law under Section 4B of the Constitution, as well as not to be deprived of property. Those are areas, Madam President, we like the Honorable Attorney General to look at as well. Madam President, as it relates to Clause 9, we are saying where the government is seeking to insert a new Section 10A, which would provide for the issuance of a protection device to an applicant. And we know that a protection device is intended to provide audible and visual warning signals that a monitor person is nearby. And therefore, it is important that the applicant who is issued a protection device accepts responsibility for its proper use and care. That is what is said in the section that I'm referring to. So this is a matter, again, Madam President, that we would like the Honorable Attorney General to look at, because we believe this section interferes with the right of the individual to respect for his private and family life. So these are areas we would like the government to look at. Madam President, as we go further into the act that is before us, the amendment rather, we have to make reference as well to the Parent Act. Because, Madam President, we are seeking to put certain transitional clauses in, well, not transitional clauses, but measures are being taken on a transitional basis to get this act going. So the electronic monitoring manager is a contractual office. The deputy electronic manager is also a contractual office. The AG had argued, and I support, in 2012, when he debated this matter, that both the electronic monitoring manager and the deputy electronic manager / director and deputy director had no qualifications stipulated for their appointments. I think this is a solid point that was advanced by the Attorney General, and I would like the Attorney General to give consideration to this matter at the committee stage, looking at possible amendments to that section of the legislation to deal with qualifications, Madam President. Madam President, I would also like to indicate that there is need for us to consider very carefully this decision to delegate, which is a very strong point, again raised by the Attorney General, then Senator Faris Alwari, to delegate powers and duties and functions of the director or general manager, Madam President, to employees of the EMU. Madam President, you cannot just delegate powers just so. What is the role of the deputy director? What is the role of the deputy manager, general manager? Why not, Madam President, delegate those functions to the deputy general manager and not just to employees? So I ask the Honorable Attorney General to look at this matter of delegation of functions to a member of the unit, which could be a contract person or otherwise permanent employee. But we would like the Honorable Attorney General, Madam President, to examine that suggestion very carefully. He argued very strenuously, and we support him on that matter. The Honorable Attorney General also argued in 2012 that we were putting the cart before the horse, and we ought to introduce what is called the parole system. The parole system has not been introduced. Amendments are now before this House. Are we still putting the cart before the house, before the horse? I would like the Attorney General to tell us this, because he was very adamant in 2012 that we need the parole system to make this thing work. We don't have a parole system. There's no parole legislation. Yet still there's an amendment to the bill without any parole legislation. Is this the cart before the horse? We would like the Attorney General to share with us. Madam President, another area of concern to us is the matter of, Madam President, of what is called there is an amendment, Madam President, here, and it deals with the director having the power to establish what is called standard operating procedures. Now, Madam President, consistent with Section 25, where we talk about regulations, we are also talking about standard operating procedures. I would like the Attorney General to explain to us in this Parliament whether standard operating procedures, even though they are linked to internal operations, whether they are going to become part of the regulations or whether they are going to form part of the substantive law. Because rights could be infringed in terms of standard operating procedures, and we would like that matter to be looked at very carefully, Madam President. Madam President, we saw where in the law that is before us, the bill, where the government is deleting the word spatial where data appears. And we wanted to get a proper explanation for this development, because this legislation was taken out of the Bahamas experience. And this spatial data referred to specific geographical locations. When you remove spatial, you leave it open, Madam President. And by extending the definition of geographical positioning system, GPS, which is not even just on Earth, but above Earth via satellite communication, it also deals with a matter that we need some clarification on. As far as the government is concerned, Madam President, we need some clarification. So, in terms of SOPs, standard operating procedures, we need to know, Madam President, where are we with those matters the regulations. Otherwise, Madam President, we are proposing that those standard operating procedures should see the eyes, the Parliament rather, should have eyes and be able to see these standard operating procedures unless we are convinced otherwise, Madam President. Madam President, we also would like to suggest that whatever contractual services are being issued, we would like that to be subject to the Public Procurement and Disposal of Property Act, which we did not see in the legislation. Madam President, as we go to clause 7 of the bill, we would like the Honorable Minister to look at what is being proposed here. The government is seeking to cover all employees as it relates to this oath of secrecy. Now, I think the Honorable Attorney General, then Senator Faris Alwari, made mention of the oath of secrecy. But we found in going through this legislation, the oath of secrecy to be very weak, very, very weak. And we would like the government to consider going to the DNA legislation and taking the very oath in the DNA legislation and substituting that oath for the one that we currently have before us. We believe, Madam President, the threshold of confidentiality should be higher than what it currently have in the bill. So we would like to suggest to the Attorney General that he examines the oath of secrecy as contained in the DNA legislation, Madam President. Madam President, we also believe that the bill, we see in the 4th schedule, they are describing the director as well as the deputy director as employees. And the director has to sign off the oath of secrecy. That is a contradiction in terms. The director has to take an oath of secrecy, but the director, Madam President, is signing off on the oath of secrecy. I don't think that is what was meant. That is why we are asking the government to look at the oath of secrecy provision as it currently exists in the DNA legislation, Madam President. Madam President, the whole issue of electronic monitoring, I would like the Attorney General to pay attention to this device being placed both on the offender as well as the victim. The victim should not have the same kind of protection device. They should have a portable device, but not an ankle bracelet, Madam President. Madam President, I have a document entitled Standards and Ethics in Electronic Monitoring out of the United Kingdom. And it makes it very clear that we have to be very careful with how we treat with victims of domestic violence. Don't put an ankle bracelet
Senator
on,
Mark, you have 5 more minutes.
an ankle bracelet on that individual, that is the victim. They are proposing, in accordance with human rights, that should be a portable device. In your pocket, as the case may be, but not on your ankle. So that's an area we'd like the Attorney General to pay some attention to as well, Madam President. Madam President, clause 14 of the bill, we don't like this concept of competent authority having the power to determine whether they should be allowed to continue electronic monitoring. A competent authority could mean a statutory authority, a tribunal, or some board. Madam President, we are suggesting to the government, the court is the one that will determine whether they will impose an electronic monitoring device on you with your consent, and we believe, Madam President, that should be the only body that should be responsible for determining whether you should continue to participate in that arrangement. Section 17 of the Act, Madam President, deals with deliberately tampering or removing such a device because of negligence. We think that, Madam President, the government needs to define exactly what is meant by negligence in this regard. And I made the point earlier, Madam President, that when you are imposing these conditions on youths and children and persons who are poor, there could be a situation of inequality and discrimination, which runs afoul of our constitutional rights to equality of the law and protection of the law. So this question of if somebody damages or in a negligent way damages or removes, Madam President, this particular ankle bracelet, which is doing the monitoring, we need to be very careful to determine, Madam President, what are the implications for poor people and whether that is not a discriminatory provision that is being advanced in the legislation. So, Madam President, in closing, I want to remind the AG of the following. Look at the clauses that we have put forward, rather, for consideration as it relates to collision with sections 4 and 5 of the Constitution. We want to ensure, Madam President, that whatever is done is not open to legal challenge in the courts. And therefore, we are saying to the Attorney General, there may be infringements of the sections 4 and 5. We need to pay attention to those infringements. We are prepared to support whatever amendments are required to ensure that the legislation is tightly arranged. And, Madam President, the final point I'd like to raise for the Attorney General's consideration. Madam President, I found it very strange doing my research that this contract that was issued to Amalgamated Security Services Limited by iGov TT. Madam President, we understand that there was an evaluation committee that submitted its report. In fact, they did the evaluation between the 9th and the 13th of July 2018. And, Madam President, they were told that they had to amend their evaluation report. I think this is cause for worry. Why would they call upon, Madam President, through the Board of iGov, TT, to amend their report? And it's after that amendment of their report, we had, for instance, this company emerging winner. We don't know because we don't have all the facts before us. Maybe the Attorney General should table in this Parliament the evaluation report of this committee so we could see that everything is above board. And why would an iGov TT board of directors, having received an evaluation report, send it back to the evaluation committee for amendments? Why was that necessary? What did they amend? These are matters, Madam President, that we consider very important in this particular debate. And Madam President, with these few words, I would like to thank you for giving me the opportunity to deal with these matters, and I want to serve notice in closing that we will be circulating amendments to strengthen the legislation. Thank you very much, Madam President.
Senator Richards.
Thank you, Madam President. I should wait until the podium is on, guys.
Yes.
Thank you.
Because you don't know what is going on.
Senator Richards, I remind you, you have 30 minutes.
Thank you, Madam President. Thank you, Madam President, for recognizing me and allowing me to make a hopefully worthwhile intervention into this an act to amend the Administration of Justice Electronic Monitoring Act 2012. Quite frankly, there's not much I have seen in this legislation, this proposed legislation, these proposed amendments to offend me. I just have some observations and some recommendations as to how I think it can be strengthened in terms of its possible application in Trinidad and Tobago. And the issue of electronic monitoring is not a new technological application in many jurisdictions. In fact, I was able to secure some information from the Scottish Centre for Crime and Research, which published a report number 8 of 2015, titled Scottish and International Monitoring Review of the Use of Electronic Monitoring. But before I go into that, I'll go straight to the proposed act and seek some clarification from the Honourable Attorney General in his wrapping up, because it kind of raised a red flag in terms of one of the concerns raised in another jurisdiction, where the definition of protection device means a small portable device which generates audible and visual indication signals received from the radio frequency tag physically attached to the monitored person. And I'm wondering if this definition is wide enough and of great enough concern that it is only intended to generate these audible and visual indication signals to identify the position of the person to which the monitor device is applied? Or does it leave room for these visual and audio signals to be actually sound and visuals, which can lead to privacy issues for the person being monitored, if indeed the device under this definition can do that? So I'm hoping the Attorney General can clarify that, and if it probably needs to be tightened to only apply to the position the person is, the geographical position the person is, in the context of monitoring the movement of the person. So I'm hoping to get some clarification on that, because if it doesn't do that, it could open the door to some privacy issues where the monitored person is concerned, and their utterances, and also their some compromising visuals possibly. So according to the Scottish and International Monitoring Review of the Use of Electronic Monitoring Report number 8, 2015, there are quite a number of very productive applications for electronic monitoring, including monitoring persons who have been accused, charged, and convicted of violent crimes. The Honorable Minister of National Security, in his piloting of this, identified the domestic abuse paradigm, which is one of the great concerns and productive applications, because we've seen in Trinidad and Tobago the fact that persons who are under protection orders and who have sought the protection of the state from persons whom they are victims of abuse on many fronts, being in some instances killed, including I think last year before, a police officer. Also the inclusion of the victim alert system, whereby the victim also gets the device. Senator Mark raised some concerns about that, if it's the same device, and if the device shouldn't have more technical abilities, because the victim is the person we're trying to protect here. So that is of concern. Sexual crimes, particularly pedophilia, and I was honored to be part of a GSC which dealt extensively with sex crimes against children, and the fact that persons who are on that registered list can now be subject to the imposition of these electronic devices, so they stay within the parameters of their release upon serving their sentences, and we are able to, through the application of electronic monitoring, identify if they're going close to schools and monitor their movements so that children are protected against these persons. Alcohol and drug-related crimes, persons who are repeat offenders and in some instances under rehabilitative orders can be monitored. It's also used for vehicle theft, people with prolific offense histories, and also, very importantly, people suspected and convicted of terrorism when they serve their sentences, if they're not life sentences, because these persons, or these individuals have to be monitored in the interest of protecting the wider society. There's also the issue which came up in the public domain regularly in the past couple of months, and I know pronouncements from the Honorable AG, the Minister of National Security, and the Commissioner of Police in terms of some persons who would have been able to secure bail for gun crimes or gun charges, and the concern that some of these persons had in their possession very dangerous weapons, including AK-47s, but they were able to secure bail. I think under these circumstances, electronic monitoring devices applied to these persons can help law enforcement and Ministry of National Security's apparatus to identify if these persons are continuing to associate with known criminals and continue to prove to be a danger even while they are out on bail. Also, electronic monitoring devices can also be used as non-custodial apparatus in terms of rehabilitation procedures to monitor persons to help with their transition out of the inmate situation, the prison situation, and into real life as part of, as Senator Mark alluded to, a parole system where persons who will be able to fulfill particular behavioral patterns and benchmarks while incarcerated may be able to be eligible for parole when we get to that stage, and certainly this will help. And also, as we've seen in situations like YTC and other custodial institutions for young persons who may have run afoul of the law, non-custodial juvenile truancy and behavioral monitoring systems where these young persons, if they meet particular benchmarks, can be fitted with electronic monitoring devices. And the other two areas I'll identify in terms of possible applications and possible amendments to this, and I think that would be where Clause 8 comes in terms of the presumed intention in widening the court's ability to apply it to various circumstances. And these two I'll cite in advance are quite controversial in some jurisdictions. In terms of persons, elderly persons, with the consent of the persons who have responsibility for them, including their children and other people, who may suffer from dementia, so they may be fitted, because some of the elderly people who have dementia sometimes wander away and put themselves in danger, and in some jurisdictions are fitted with these devices with their consent or the consent of those persons, their children or their offspring in those instances that have responsibility for them, so that they can be found if they wander off. And also another controversial application is persons who have in terms of persons with mental health issues, psychological issues, where the challenges may render them not always corpus mentis and incapacitated to the point where they are a danger to themselves and others. And in those instances, under the prescription of a qualified mental health care person, that individual can be fitted with an electronic monitoring device for their own safety. I already identified community reintegration for rehabilitative processes, and also these devices can be applied as an alternative to remand. We all know of the very challenging remand situation we have in Trinidad and Tobago, where in terms of some low-risk persons or some what may be considered minor crimes, these persons can be fitted as an alternative to remand to support pre-trial conditions and for persons with possible shorter sentences. And one of the also controversial applications to electronic monitoring is the issue of law enforcement and national security agencies using monitoring devices. And we usually think of these electronic monitoring devices in terms of the bracelet on the ankle alone. But in some jurisdictions, they have evolved into chip insertion into the human body for undercover officers who go undercover to unearth and dismantle gangs, terrorist organizations, etc., where the state, the person is a law enforcement agent in some aspect and is fitted with the electronic monitoring device, and that monitoring and the information gleaned from that can be used and admitted into court. Also, in terms of the issues that where this can be applied, and I don't know if it's taken into contemplation in this proposed legislation, is the monitoring of high-risk inmates. And on several occasions, we've had information from the Honorable Attorney General, the Minister of National Security, about what individuals who have been deemed high-risk inmates who continue to communicate with the outside world and interact with other inmates and run criminal syndicates from inside prison walls. And in other jurisdictions, we found it has been found very useful to fit these inmates with electronic monitoring devices so that the surveillance of them can be more on a 24-hour basis in the interest of thwarting their criminal and nefarious efforts. In terms of the cost as identified by the Honorable Minister of National Security, he cited $10.3 million in 3 years, and I will tell you that this cost is actually much cheaper than the cost as identified in this paper that I cited earlier on in Scotland, where the average unit cost for electronic monitoring in Scotland between 2013 and 2014 was £743. You know, it started actually at £1,940, and in 2011 was as much as £1,043.73. And according to my quick calculation, and I hope I'm not wrong and will be embarrassed, but that means that the unit cost for 300 units identified in the Minister of National Security's deliberation brings it down to $4,333 per unit, which is significantly lower if that is the case over the 3 years. My question is that if that is the identified expenditure over the 3 years, is it that we have not factored in maintenance cost and also expansion of this program if it's proven to be successful within that 3-year period? And what sort of phased implementation do we have intentions of doing where this is concerned? So I would actually want to know what the plan is where that is concerned, in addition to the fact that, you know, Senator Mark raised it, but I also have a concern about any particular private sector entity having an increasing footprint in national security as much as I'm seeing developing in Trinidad and Tobago. And that's not to say that I have an issue with the private sector entity as identified, but more and more we are seeing specific private sector entities, in this case Amalgamated Security, having more and more of a significant footprint in the national security grid. And I don't know if that's as much a productive development, especially since I don't know what the private sector entity in this case is bringing to the table that the National Operations Fusion Center and the Ministry of National Security couldn't do itself in terms of doing the research for international competence. In this case, the company with which Amalgamated liaised is Atenti, which is a well-renowned Israeli company, which is a very good company. But I'm not seeing the value brought past being a very successful, very effective broker to find an international agency that can provide the equipment and the competency and apply it in Trinidad and Tobago. I don't know that the Ministry of National Security or one of its agencies could not fulfill that mandate. So I'm wondering what Amalgamated brought that the Ministry of National Security's personnel or the National Operations Fusion Center could not do. So if someone could provide me with that information, I'd be very comfortable with that. But as it stands, I'm not seeing what role, responsibility that the company brings that we could not have fulfilled within the Ministry of National Security. In terms of arguments for electronic monitoring, as I said before, I'm all in favor of this. It's way overdue. The research proves that 60% of all prison sentences of less than 6 months can be executed at home with electronic monitoring. And there's a high degree of compliance with electronic monitoring in those jurisdictions. Research, less than 10% are revoked for compliance breaches. And electronic monitoring has a much lower recidivism rate, 17% compared with custodial prison sentences at 38%. Electronic monitoring is much cheaper than incarceration in prison, and it is more applicable to facilitating a better rehabilitative process. Some of the concerns that I have also include the reliability and efficiency of the ICT framework upon which this must run in terms of the information and the GPS positioning of persons who will be fitted with these devices, the response time of law enforcement, particularly in cases of sex offenders and domestic violence situation, penalties for non-compliance, and there are some legal questions that I hope can be answered in terms of how will the court view cases involving a failure to respond to an alert by law enforcement that may result in a new crime? That has been raised in other jurisdictions when the information is that the person is within the commission of a crime, the officers don't respond in time, and another crime is committed while that person has been fitted with an electronic monitoring device. The person commits another crime. So in other words, the device has failed to prevent, and does the state become liable in some way to that? How will the courts view cases involving a new crime committed when the radio signal is lost during equipment malfunction? How will the courts view the admissibility of location data points and reports from GPS vendors as a third-party conduit for this process and this project? How will the court view privacy rights challenges in these cases? How will the courts decide on potential issues of cruel and unusual punishment and public expectation balanced? And we also need to set in place a system of using the data that will be collected during this phase, this implementation phase of the electronic monitoring device, should of course this meet muster and pass in this honorable house. What kind of research are we going to gather? As I'm saying, I've quoted extensively from the Scottish Centre for Crime and Justice Research, report number 8 of 2015, and part of what their mandate was upon the implementation of their electronic monitoring, which dates back about 15, 20 years, was in terms of using the data gleaned to provide research and criminal justice in that jurisdiction, which can help, one, better law enforcement responses, better state responses, and guide policy in a more productive manner. So I'm hoping that part of what we will see coming out of this is the issue of related to research, data gathering, and analysis from the competent authorities. So with those few words, Madam President, I thank you for the opportunity to contribute. And as I said before, I don't see very much in terms of content as offensive in this. I just suggested some expansions of the possible applications, and I asked some questions, and I hope the AG, in his wrapping up, can provide those answers. With those few words, Madam President, I thank you.
Senator De Freitas.
Thank you, Madam President. for the opportunity to contribute to the bill that is engaging the attention of this honorable chamber, which is an act to amend the Administration of Justice Electronic Monitoring Act 2012. Madam President, at this current time, I can say that I am happy, and I'll tell you why. In 2015, 2016, one of the first things that the Joint Select Committee on National Security did was to take a look at pieces of legislation which required some follow-up that would have a great impact on national security. There were two that were identified. First being the DNA legislation, which we dealt with, and we brought regulations to this House. And the second was this piece of legislation that is before us today. And I say so because that Joint Select Committee on National Security did follow up with the entities responsible for bringing this piece of legislation and operationalizing it. I'm glad that Senator Mark indicated in his contribution that any attempt to strengthen this legislation will be welcomed, especially whereas in this chamber we tend to have a difference of opinion. But I just want to respond to Senator Mark in relation to the other comments he made, whereas he indicated that it took the PNM 4 years to bring changes and we're on the way out. And what I want to say to Senator Mark is when you're dealing with crime legislation especially, a bipartisan approach is always required. And I could easily respond and counter that argument by indicating this legislation was passed in 2012. It required some form of follow-up and operationalization after, but nothing was done. But that would be a moot point because it doesn't really help the situation. And therefore, I could also go on to say that it took 7 years to get this operationalization working. And the reason for that is because this particular process of electronic monitoring is not a simple one. It's going to be complicated. And the Minister of National Security would have alluded to that when he spoke to some of the things that needed to be done in terms of training for the TTPS, in terms of acquisition of the devices. And Senator Mark kept asking the question as to whether there would be testing or if any pilot phase would have been done. But because this particular operationalization of this piece of legislation requires something to be functional, then I want to believe that testing must be done and that the piloting of it would have been done because it could not have been rolled out. So to Senator Mark, I would indicate it's not about what the other side did or what the other side didn't do, but it's about what we can do together to ensure that we curb the scourge of crime in this country. And so, Madam President, as I normally do with crime bills, I try to create the context in which this piece of legislation works with other pieces of legislation to ensure that we consistently and continually reduce crime in this country. And we indicated early on in this 11th Parliament that there are 5 pillars that we always look at when we're talking about crime legislation. And that is prediction, deterrence, detection, prosecution, and rehabilitation. And this piece of legislation speaks specifically to prosecution, detection, and deterrence when we're talking about electronic monitoring. And so, Madam President, electronic monitoring, to me, and as most speakers before me have alluded to, helps in the sense that it gives us more data to work with when we're dealing with individuals whose behavior is errant to what society deems normal behavior. And so, for the purposes of this piece of legislation, Madam President, I will talk about the positives, which you can find in Clause 8 of the bill. And a lot of the speakers that have gone before me have spoken to the effect of reducing the individuals on remand, and Senator Richards would have just spoken to that, so I won't go into that too much. The Minister of National Security spoke in great detail about the ability of the judicial system to use it as an alternative to incarceration, especially for minor offenses. and therefore reducing the prison population, which Senator Mark, in his contribution, indicated was the general purpose of the bill when they passed it in 2012 under that previous administration. But one of the other points that was not made that I want to raise today as a potential positive is the ability to use this particular system in the witness protection program. And as much as we have, Madam President, the evidence amendment bill before us that we're treating with, and that witness protection program and things that come up in that bill to treat with that, this is another avenue where in some form or fashion we can utilize this electronic monitoring system and the protection unit that this bill speaks about in terms of helping out the witness protection program. And of course, that would be very specific to the unique circumstances upon which a person might find themselves in the witness protection program. And if I was just to try and talk about that for a second, it would speak to, one, a protection device for the person in the witness protection program. And if a threat as a result of a particular individual could be identified towards that person, then it may be fitting to have that person outfitted with an electronic monitoring device so that that witness has extra protection. And for me, that is an added positive to this bill in terms of that program that no one has spoken about just yet. But Madam President, let me move to Clause 9. And the most important clause in this bill, as it treats to a situation that has been too prevalent in our society, and that is domestic violence and victims. For as long as I could remember, we've heard the stories over and over again. A victim takes out a restraining order. The restraining order does little to nothing in terms of protection, especially if the perpetrator upon who the order is put is determined to do harm. Too long had we heard of the victim's plight. Too long have we heard that the restraining orders have been ineffective. Madam President, Clause 9 in this bill is to a domestic violence victim what water is to a man in the desert. It is life-saving. And just to bring that point home, I want to draw your attention, Madam President, to a newspaper article in the Daily Express on January 27, 2020, titled, "Wife Murdered Outside Couva Workplace, Husband Commits Suicide." There was a murder-suicide in Couva on Monday morning. It happened in the parking lot of the Venture Credit Union along the main road. The building is located near the Couva police station. Police said Nai Singh, 31, exited her vehicle and was attacked by Roger Singh, 32, her husband. He was waiting for her in the parking lot. And Madam President, I'll stop there, because Clause 9 speaks to ensuring that victims, upon their request, are able to have a protection device which will alert them by audio or visual tones as to when someone who a restraining order has been put on is close by. And based on what I've just read, you can tell that had we had this piece of legislation and that piece of operationalization, that individual would have been able to acquire that protection device. And this entire newspaper article could have been read differently. She would have been alerted to the presence of the perpetrator. And she would have been able to find shelter or to seek help very quickly. She may have very well still been alive today. And I think that is why this clause in this bill is so profound and is so important. And I commend the Attorney General and the drafters of that amendment for this bill for thinking ahead enough to put that in this bill to ensure that domestic violence victims have a fighting chance beyond just getting a restraining order. And so, Madam President, in response to Senator Richards, who wanted to find out, by way of the definition in the bill in relation to this protective device, for me, I can say that when I read the definition, I did not think that it meant that you would be able to hear what the perpetrator is doing or that you would be able to see what the perpetrator is doing. Because in the definition, it speaks to radio frequencies in relation to the anchor bracelet. Now, I'm not a techie person, but when I heard radio frequencies, to me, when I read audio and visual, I immediately thought you would hear an alarm or the device, this is the protection device, would either buzz or give you some sort of a visual representation like a bell ringing or something on your arm, just to alert in a split second the victim that the person you took the restraining order out on is very close by and you need to seek protection or you need to seek shelter. But if it is required that the definition needs to be more specific to indicate that there can be no listening or there can be no visual cues coming from the perpetrator, well, then I leave that to the Attorney General to treat with. But that is not what I got when I read the bill in relation to that protection device. Senator Mark spoke to some of what he perceived to be the negatives, and that is the oath of secrecy. And he felt that it was too weak in this bill. Now, the thing about institutions, Madam President, is that you have individuals that work within an institution. And inherently, once you have anybody working in an institution, then that institution can be weakened by the behaviors of those individuals. And I found it to be comforting when I read the oath of secrecy and the extent to which it went in this bill. Because one of the things that could happen to bypass any protection given, especially in a domestic violence situation, we do live in a relatively small society, 1.3 to 1.4 million people. And it could be that someone in the process of dealing with executing that electronic monitoring order could end up trying to warn a family member that such an order is pending or coming. And that is why the oath of secrecy in this bill, which speaks to individuals in electronic monitoring unit, it speaks to those who are doing consultancy work, and it speaks to anyone who comes into that contact with information in relation to that process, being sworn to an oath of secrecy, not just while they're working with the electronic monitoring unit, but even after they've left the unit, or even after they've completed work in relation to that process. So to me, the oath of secrecy, Senator Mark, is perpetual. It continues. And that is very important for the effectiveness of this. Senator Mark also spoke to the standard operating procedures. And I will leave that for the Attorney General to deal with. But what I was comfortable with is the fact that it was implemented in Section 25, that the rules and the processes could be put in place by the judiciary through their Rules Committee. And this is important because one of the bodies that has a large amount of knowledge in relation to dealing with cases of domestic violence is the family court, Family and Children's Court. So the ability of the judiciary through their Rules Committee to set up rules in relation to this particular process Who, when, how, what, why?
Senator De Freitas, you have 5 more minutes.
Thank you. To me, it's very important because they will have that knowledge going back as long as that system has been there in that judiciary, to make sure that it's effective and to make sure that it has the intent that this bill is trying to execute. So, Madam President, those are the things that I wanted to say in relation to the bill that is before us. This electronic monitoring is going to allow us, once again, to be able to consistently and continually reduce the level of crime in this country. We are adding tools to the system that allows us to, one, get feedback, use that feedback to ensure that the pillars that I've identified in the beginning of my contribution, that we hit each marker in relation to those pillars so that we can live comfortably in Trinidad and Tobago and that we do not have to worry about any level of rising crime. With those few words, Madam President, I thank you.
Senator Amin.
Thank you very much, Madam President. I thank you for this opportunity to contribute to this bill, the Administration of Justice Electronic Monitoring Amendment Bill 2020. The Parent Act was passed by the People's Partnership as one of 3 pieces of legislation, criminal justice bills, which was described by the former Minister of Justice as having a view to transforming and modernizing the criminal justice landscape in Trinidad and Tobago. And it was just one of the measures proposed by our government in the overhaul of the penal justice system. It was modern. The vision for our penal system was modern, innovative, and technology-driven. There is no doubt that the government, the present government, also believes that our present penal system needs an overhaul. Introducing electronic monitoring as a new sentencing option would have the effect of reducing prison overcrowding and introducing a more effective prisoner management system. The act that was assented to in 2012 remains to date to be proclaimed. And I find myself agreeing with, I think he's Minister of National Security, one of the ministers, Mr. Fitzgerald Hines, Minister Fitzgerald Hines, who at a GSC said it is very, very clear that we are behind schedule and this matter is long overdue, embarrassingly so, end quote. Madam President, it appears from the members who have spoken so far on the government bench, as well as utterances in the public domain, that the government is seeking to introduce the 2020 Amendment Bill at this particular time to serve 2 roles. I just want to quote the Attorney General at a media conference who indicated, "The bill is materially important to everyone in 2 areas. 1, it is connected to how we manage prisoners who may be released out of the system. And number 2, very importantly, it is connected to the issue of domestic violence." Madam President, given the government's recent announcement that it plans to release certain sectors of the prison population, described as low-risk prisoners with a view to managing the spread of the COVID-19 within the prison system, it is evident that this move is also primarily responsible for the government's move to have the bill brought to the Parliament at this time when even the Parliament has been asked to deal with only the most essential matters. This bill will allow the government or the state to enhance the current conditional release program as more inmates can be released from our correctional facilities. Madam President, Senator Mark would have mentioned the opposition, then opposition's, request and suggestion for a pilot project for electronic monitoring. The Attorney General has proposed simultaneously testing a novel and technology-driven system of electronic monitoring. And it was mentioned before that a pilot project did not occur, did not materialize. One of my questions to the government, given that the Attorney General and others would have indicated, in fact, let me be very precise, on the 1st of April 2020, the Attorney General indicated that there were 388 prisoners, non-violent offenders, who had been identified thus far and who would be eligible for early release. And these offenses included failure to pay maintenance, traffic offenses, use of obscene language, marijuana possession, and resisting arrest, end quote. The number of prisoners that the Attorney General indicated, it quite falls into the number of devices we are told have been procured or a contract has been awarded to procure, which was 300. Is it that the government intends to use this COVID pandemic recommendation of the World Health Organization to allow prisoners to be removed from correctional facilities with electronic monitoring as their pilot for this electronic monitoring device to be used in Trinidad and Tobago? If that is so, there's no problem with that. But you should tell the population that out of this exercise, you intend to gather lessons, gather data that would improve the system before you go forward. I think it's very important for the state, the policy makers, our criminologists, our judiciary, to have information in addition to what exists in other jurisdictions, but in what happens in Trinidad and Tobago, how our culture, our population, the size of our country would impact on the use of these devices and ways that it can be improved. Madam President, I say this having regard to the fact that there are a number of countries that are presently implementing this early release scheme. The United Kingdom, France, the US, Germany, Australia, and Canada. It is a worthwhile effort for Trinidad and Tobago to consider this early release and how we qualify prisoners for that. Madam President, the present pandemic provides that opportunity, but my question to the government and for, in fact, the nation to ask the government and ask ourselves, by the time this legislation is passed in Parliament, operationalized, implemented, training taking place, is this measure really for the coronavirus response? Is it really going to come in time to prevent the spread of COVID-19 in prisons? The government should share their view with us in terms of what their intention really is. And as I said, that raising this matter is not me objecting to the system being put in place. Madam President, another issue that I would like to have clarified is where in Clause 6, the government proposes to delete the word spatial and now have the electronic monitoring unit maintain a historical record of all electronic monitoring data, as opposed to just spatial data. Now, I am not quite sure that the members opposite have explained to this Parliament the reason or full justification or giving a full justification of requiring all that data. So spatial data really indicates activities, locations, schedules in real time, as opposed to all data. So this all data could include names, interactions, other private data collected via the electronic monitoring device. And it may be viewed as a good thing in that there would be an abundance of information that can be referenced in if any future offenses take place. But on the other hand, we must weigh how invasive collecting this type of data would be, since it encroaches not only on the monitored person's privacy, but also that of those he or she may interact with. Would all data include audio, images, etc.? So, Madam President, if the members on the other side could explain why all data as opposed to simply spatial data. The Standards and Ethics in Electronic Monitoring Handbook from professionals responsible for the establishment and use of electronic monitoring, Dr. Mike Nellis, Council of Europe, in 2015, defined electronic monitoring as electronic monitoring technologies enable judicial and executive authorities to restrict, regulate, and enforce a suspect or offender's spatial and temporal activities, their locations, movements, and schedules at a distance, often in real time, potentially in a very finely calibrated way for periods of variable duration. Contemporary monitoring technologies focus on pinpointing offenders at fixed locations, following the trails of offenders on the move, or alerting authorities when the perimeters of designated exclusion zones are about to be crossed separately or in combination. Are we, Trinidad and Tobago, setting a new definition for what an electronic monitoring device will do by removing the word spatial data and allowing the monitoring device to be able to collect all data? Notwithstanding this question, I also want to suggest that it's very important, if the state is going to collect all this data, that we must have adequate protection mechanisms, particularly for the data outside of what is defined as spatial data, outside of what is acceptable to be collected by the justice system or the penal system or the state, in fact, in all the other jurisdictions. Protection of that data for the protection of the privacy of not only the person who is wearing the device, but also the persons who that person might interact with. Madam President, I now want to move to Clause 9. But first of all, let me say Clause 8 has expanded the grounds on which an electronic monitoring device may be used, and they include bail, protection order, probation orders, community orders, and any other application which the court, in its discretion, deems fit. Madam President, one of the areas that I think all members here would be happy to see is Clause 9, where an order for protection is made under any written law. The court may inquire of the applicant whether that person consents to being issued with a protection device. So one, you have consent of the applicant, and where the applicant agrees to being issued with a protection device under subsection 1, that the applicant shall complete the prescribed form indicating that they understand the purpose of the device and accept responsibility for its proper care and use.
Senator Amin, you have 5 more minutes.
Thank you. This new section provides for the issuance of a protection device to an applicant, and it is intended to provide audible and visual warning signals that a monitored person is nearby. So the applicant who is issued in with the protection device accepts responsibility for its proper use, but can also receive alerts. This section basically seeks to allow electronic monitoring to protect victims and survivors of mainly domestic abuse crimes. If I am permitted, Madam President, I would like to share an excerpt which captures my belief and principle in the use of these devices for victims. Using electronic monitoring to protect victims necessarily involves the police in its use. It is only ethical to use electronic monitoring devices with crime victims, usually victims of sexual offenses, stalking, and domestic violence, if the effect of doing so is empowering to them, empowering to the victim. If they feel less vulnerable to re-victimization, more protected knowing that the police know both his or her as well as the suspect or offender's whereabouts, if they feel safer in their own homes and when they move about in public. Victims must only be offered portable receiving devices to pick up a signal from the offender's tracker, never persuaded to wear a tracker themselves. So this comes to the point that Senator Mark made, where the device that an applicant is issued should not make them feel like they are in shackles. If real-time location data shows the offender and victim coming into proximity of each other before visual contact, the urgent provision of police support to the victim and seeking out and intervening with the offender. Madam President, this is an important point. When we look at the operationalization of this measure for victims of domestic abuse, notwithstanding the additional security that the device can provide to the victim or survivor or applicant, managing these technologies require considerable technical and other support resources. My question with regards to this point to the government: what protocols are in place for interaction between the roles of the electronic monitoring unit, the gender-based violence unit, operational from the 1st of, I think, January this year, and the emergency responders unit with regards to victim protection? The Minister of National Security did indicate when he was piloting this bill that the EMU will notify the police. But Madam President, what is the record of the police in responding to these types of reports in Trinidad and Tobago at present? Madam President, even with the most sophisticated alert and monitoring systems that these devices will provide or intend to provide, it will come to naught if the police response times are not significantly improved. If the system of alerting a responder who can immediately be on the scene has any hiccups, a bracelet alone, a device alone will not protect a victim of domestic violence from an offender who is hell-bent on killing him or her or causing any harm. Madam President, in Trinidad and Tobago, a number of women have lost their lives due to domestic violence and the existing situation. I want to ask that we take this opportunity to ensure that the NGOs and other stakeholders who work with victims of domestic violence have an opportunity to have an input in the operationalization of this particular measure. I thank you.
Senator Choate.
Thank you, Madam President, for the opportunity to make a brief contribution towards the proposed legislation before us. I must commend my colleague, Senator Khadija Amin, for an excellent presentation, and in fact, the quality of her presentation will make mine even shorter. But there are a few points that I think I have to make. And I apologize if briefly I may repeat some of the points made by my colleagues earlier. But I think, Madam President, I am struggling a bit with the mask. So I was not able to take my place at the head of the line as I had promised. I too, in the wording of the Act, observed that the GPS system contemplated, that's to say the satellite system, seems to empower the agency to fit units which can pick up audio. Put simply, that may allow the person who's wearing the bracelet to be recorded without him knowing about it, and also anyone around him may also be recorded. That would be in breach of their constitutional rights. And I think that if there is any way in which this language may be amended to make it clear that it is just intended to be used as an alert, then I think we ought to tighten it up. And Senator Amin, by going into the definition of the word spatial, brought the point home quite effectively, I think. But when I saw radio frequency, I thought to myself, well, how do we as parliamentarians know that radio frequencies will only be used for a particular purpose? Now, because we are not experts and we are not familiar with the technology which is going to be used, I think as lawmakers, it is incumbent upon us to ensure that the law doesn't permit those executing the legal obligations and responsibilities under this Act to go beyond the ambit of what is permitted by the law. So that is my word of caution with respect to that. Now, I had another question with respect to these devices, because it seems to me as though these devices may be monitored, or the agency may be working in conjunction with current telecommunications providers. I am not clear on that. Is it that they have to go separately to get a telecommunications license, or are they going to work with existing telecommunication providers? And the question which we have to ask is, how do we regulate the working together of the agency with the personnel and the assets of the telecommunication provider in question? I don't think that I know enough about the technology to take the point any further, but it is certainly something that I would like to find out more about. Now, one of the points that I wish to address, and I suppose I'm jumping about a bit, but it is an issue which I had when the legislation had been passed in 2012. And that is the issue of, when you look at, I think it's the second schedule of this proposed legislation, you see that one of the things that a court will consider in determining whether a bracelet or an ankle bracelet will be permitted to be worn is the means of the person. Now, I have to say, I object to that. I think that this is a cost which the state must absorb for the safety of all of its citizens. To say otherwise would allow the young person with wealthy parents or wealthy backers to be able to convince the court that if you put a bracelet on me, I can happily get bail and continue with my life because I can pay for it. Whereas the young person with no such financial backing, of course, may not get bail because they cannot be tracked. And I think that would be grossly inequitable and unfair, and I would be grateful if the Honorable Minister could give consideration to that factor being removed from the schedule. In terms of parties being liable for the negligently damaging these devices, this is what I have to say. I don't see that this particular section makes a great deal of sense. Because if a child, what test are we going to use for a child as opposed to an adult? What duty of care are we going to impose upon a child when we determine that the child has been negligent? And if the child has been negligent, let's say the child went to play football or jumped into the beach or got sand into the device and it stopped working, who is going to be able, who has to pay for that? There's nothing in the legislation which provides for it. I think the easiest thing to do might be for the state to take responsibility and simply insure these devices. That would mean that we remove the inequity, we ensure that we don't have a bugbear about what to do if a device is negligently damaged and so on. I think our focus should really be on the people who try to tamper with the devices or try to get them off. And criminalizing such activity, of course, is entirely appropriate. So I think this whole thing about negligence, I mean, while you want to impress upon the person who gets the ankle bracelet that you must take good care of it, you're not supposed to damage it, and so on, I don't think that it's necessary for us to have that included in the legislation. Now, I know that this suggestion may not be universally acceptable. But I know that we are only going to get about 300 units if I followed what the Minister of National Security had to say. And I will respectfully ask if some consideration could be given when those units are being considered for use, whether they could be given in terms of priority. So where you have domestic violence applications, for example, I think if we have a limited number, they should be at the top of the list. Secondly, we should have persons charged with sexual offenses, and I pause to give an example. A real-life example. There is a gentleman who one may refer to as a repeated sexual offender. And while he was being prosecuted for one of his offenses, he decided that he was going to stalk the female prosecutor. And it was a terrifying experience for her. And I think we have to appreciate that certain kinds of offenders need to be monitored very closely. So if we have a limited number of units, there must be something that we can put in here to say that priority should be given to domestic violence cases, because too many women have lost their lives, and also to sexual offenses cases or serious sexual offenses cases. Now, the other thing I would ask the government to consider is, I know the government has said that the Rules Committee will be drawing up rules for the use of all of this and so on. But I think the proper thing to have done was to have regulations attached to this piece of legislation in the amendment. And let me say why. Because the judiciary has gone past the day when they draw up procedural rules for every single thing that has to do with law enforcement. Yes, we had the judge's rules from 1964, which govern the admissibility of confessions and that kind of thing. But legislation has been introduced in this parliament to say that those judges' rules will no longer apply, and the proper way to approach it is to have legislation, whether primary or secondary. We should have legislation hashing out what is acceptable and what is not acceptable. And the reason I say that in particular is because I think any rules that deal with how children ought to be fitted with bracelets as opposed to adults should be separate. It shouldn't be one set of rules for the fitting of bracelets on children and on adults. Because when you have children concerned, you fit a bracelet on a child, and that child, you have to remember, is going to have to go to school with that bracelet, with all that follows from that. And the bracelet may actually be giving the child his liberty to be out of a prison, but it may be harming him in so many other ways that we cannot imagine. So I think there ought to be different considerations in the rules when it comes to braceleting children as opposed to braceleting adults. So if we have to go with the Rules Committee setting up rules, then I would respectfully ask if some consideration could be given to the separation of rules for children as opposed to adults. Now, because these rules will govern things like liberty, perhaps admissible evidence, and this kind of thing, and may deal with issues of privacy, I thought that the rules should be subject to positive resolution, to the positive resolution of Parliament, not the negative. because this is a piece of legislation which requires a 3/5 majority. So I think that to say that the rules which are to be proposed must be subject to negative resolution is illogical. It's inconsistent with the thinking of the legislation as a whole. So I know that much has been said prior to my attendance this morning about this piece of legislation, but these are the few points I would like to make, and I hope that some of them at least are taken on board. Thank you very much, Madam President.
Senator Timal.
Thank you, Madam President, for the opportunity to contribute on this bill and act to amend the Administration of Justice Electronic Monitoring Act 2012. Madam President, I think a couple of speakers before me would have intimated about a pilot project, because in almost all the jurisdictions, in fact most of them, for the introduction of the EM systems, pilot projects serve as an introduction for the verification, for the trial run, for the sustainability of such systems and its effective use in managing the prisoner population. It is indeed noteworthy, Madam President, that whilst we are exposed to a present type of incarceration, the COVID incarceration, that we are looking at a new form of incarceration referred to in many jurisdictions as e-carceration. And we have heard from speakers before that the EM system, Madam President, is going to be used, or is intended to be used, for a very wide cross-section of judicial decisions that prohibit both contact and incarceration itself. And we have heard about pre-trial detention, those who would be on bail, alternatives to prison incarceration, early release from prison, protection of victims, particularly domestic violence, particularly in the case of domestic violence, surveillance and tracking of offenders who have committed sexual crimes, and generally judicial decisions prohibiting contact with persons and victims. Madam President, it's just because of this wide range of offenses that the EM system is intended to address. And with the introduction of just 300 units, 300 devices, as we heard from the Ministry of National Security, as the first batch based on the contract awarded to Amalgamated Security. I was just wondering, Senator Choate mentioned about prioritizing what really the focus would be within such a small amount of units, and which category of offense that emphasis would be placed on. Because although it hasn't been fully stated that the 300 units may serve as a pilot project, it is appearing to me that in effect, it would be along those lines of a pilot project. And in such a case, in order to derive enough data over this three-year period for the implementation of this first phase of the EM system in order to see how it operates. What percentage of the units are going to be allocated to which category of offense in sufficient quantities to allow effective and proper assimilation and evaluation of data that comes from this monitoring exercise. And maybe, someone from the government side could probably indicate to the House, if there are any thoughts or plans regarding this aspect of the system to be introduced. Madam President, it is obvious that there are high social and political expectations with regard to EM programs. But at the same time, as a country, we must be mindful of making safe investments with regard to technological investments and making investments that are beneficial from a cost point of view to the overall well-being of the country. I'm not sure what projections have been done about the expected cost benefit brought about by a corresponding decrease or expected corresponding decrease in the prison population. Because when we look at $10.3 million applied over 300 units for 3 years, and then we add on the overheads of the monitoring unit and all the associated administrative overhead costs, we are well looking at definitely over $300,000 per device for the 3 years, which is indeed a substantial cost to the nation. And in that context, Madam President, from just looking at it from a purely punitive measure, we need to see EM as not as a replacement, but as a tool to support the execution of sentences or penal measures, and to be used as a strategy to intervene with dependence on convicts in an effort at rehabilitation and social reintegration. And it is this rehabilitation and social reintegration that will really add to the overall cost-benefit analysis of EM systems. And which is why I'm suggesting that our model here in Trinidad, whilst combining both control and intervention, should place a greater focus on control or social reintegrative actions. The regulations, Madam President, should therefore be structured in such a way that the EM unit ensure that the surveillance and intervention are geared towards the needs of social reintegration and not purely guided by punitive protocols. Regulation should ensure in detail that all of the possible problems alerted by the system, coming out of what categories they are given within, that all possible scenarios alerted by the system should have a clear reaction scenario laid out in the rules and procedures with the subjects, appropriate for the specific situation and the risk that the potential non-compliance represents. Madam President, and this would ensure, in terms of the overall cost benefit, that if we are to add in the reintegration, the benefits of social reintegration into the equation to make this a cost-efficient exercise, then our regulations should really address this as well. Madam President, before I get into the bill itself, I just want to make one point that our rules and procedures and regulations should also deal with procedures to be followed when the GSM or the GPS system goes down, since lives may be at stake, whether it may be minutes or parts of hours that the system goes down, lives may be at risk, particularly in the case of domestic violence victims. Madam President, I'd like to go to page 2, section 4, clause 4, section 3 of the Act, of the bill, part A, under the definition of occupier, where an amendment is proposed for the definition of occupier, where it says that the occupier may mean any person exercising control over that part of the premises where the equipment is to be installed for the time being. I'm not that well versed in crafting legislation, Madam President, but by the use of the word equipment here, both in the Parent Act and all the way through the amendments, we have monitoring instruments, protection device, monitoring device, appearing at several instances within the amendments and the Parent Act. And here we have introduced the term equipment. And I was just wondering if legislatively we should have married that term equipment or replaced that word equipment with monitoring instrument, protection device, or monitoring device to be consistent with the definitions within the bill. Madam President, I would like to go to clause 5 of the proposed amendments, where with the introduction of section 4A, clause 4A, where it says that the functions of the director under this act may be delegated in writing by him to an authorized officer who shall be a member of staff of the unit acting under and in accordance with his general or special directions. Madam President, the powers and the duties vested in the director of the EM unit is indeed wide-ranging and exceedingly important. And I would submit that should the director decide to delegate to an authorized officer any of those duties and responsibilities, then such delegation should at least be subjected to the approval of the minister or the consent of the minister. Because here we would have the director of the EM unit deciding to delegate functions without any consultation or authorization from anyone per se. And I think there should be some form of oversight with regards to this delegation. Also in section 6, with the introduction of 6A, where it says the director may from time to time as necessary issue standard operating procedures for the proper functioning of the electronic monitoring unit. And again, these standard procedures that are being issued by the director, what oversight is there in the whole process of the development and issuing of these operating procedures, or whether there should be some form of ministerial oversight prior to the issue of these operating procedures. Madam President, on page 5, clause 7, where it speaks about this oath of secrecy, and the oath of secrecy is limited to an employee of the unit, or as is stated here in the clause, an employee of the service provider. And my question is, what about the secrecy of the service provider himself? Because the unit is going to engage, of course, in engaging service providers in order to fulfill the objectives of the monitoring unit. And whereas individuals are being charged with that oath of secrecy, as a service provider, as a subcontractor, somebody engaged by the unit, is the confidentiality clauses going to be included in that arrangement with the service provider and the unit itself, or do we need to legislate an actual oath of secrecy regarding the service provider themselves? Madam President, in clauses 9 and 9, where it speaks about the protection device and responsibilities for proper use and care, I know Senator Choate spoke about the whole question on the ethics of the cost of the device. And not only the cost of the device itself, because other than the initial capital cost of the device, there will be an operational cost, of course.
Senator Timal, you have 5 more minutes.
Thank you, Madam President. And in such a case, as she had mentioned, whether it's a potential for abuse by those who can afford the device to apply to the courts to actually get the device. But this is something I think that because of the heavy investment that the state is making, there has to be some mechanism where some aspect of the cost could be recovered. And maybe consideration has to be given in the whole rules and procedures of who would qualify for such a device based on application. Is it going to be categorized? Is consideration going to be given to social factors, personal factors, and other factors that would allow some equity in the allocation of these devices or approval for the person to get a device on application? Madam President, in section 11, where it says that the competent authority, Part A, may also request a report from any other person where applicable. Madam President, I'm wondering why so broad? Because here we have an electronic monitoring unit that is being set up at considerable expense, where within the unit there would be expertise, and then also the unit has the ability to contract service providers to provide services as well. What other person would there really be? What would necessitate such a need for the court to have, or the competent authority, to request a report from any other person where applicable? Would not the unit or the service providers it engages be sufficient? And with these couple of words, Madam President, I thank you.
Honourable Senators, at this juncture, the sitting will be suspended and we will return at 1:30 p.m. So the sitting is suspended until 1:30 p.m.